All right, everybody is here. That's great. So the next panel is called Power Shift, and our moderator and chair who put this all together is a associate professor, so a new professor at our law school who's already made a huge name for herself. This is Anat Beck. She has a weekly column in Forbes magazine, so she's quite famous in her own right. She does business law and international law, and she's a graduate of Cornell Law School, which I know several people in this room are, and we're really happy to have you joining us today and moderating this panel.
Thank you so much. Thank you. It's really an honor to be with you today. We have amazing speakers, and what we'll be doing, we'll be discussing Power Shift, Security Council Paralysis, and General Assembly Ascendance, and we'll change the order a little bit. What we'll do is we'll have speakers, I'll be presenting questions to them, and they'll be answering them. And we have a really nice young lady here, thank you, to help us with the time. We're going to have Tom Bockwald, Michael Scharf, Karsten Stan, Paul Williams, and Ved Nanda. And I'll start with our first speaker, Professor Bockwald. Todd Bockwald is a member of the United Nations Committee Against Torture. He's a distinguished professor, scholar, lecturer of international law. He previously served as the U.S. ambassador at large for global criminal justice with a focus on justice and accountability for atrocities. And this followed an acclaimed legal career with over 30 years in government and private practice, including serving as an assistant legal advisor of the State Department with a focus on United Nations affairs, and as an attorney in the Office of the White House Counsel. So it's an honor to have us with us today. And please, the stage is yours, and I'll be presenting 2 questions for you.
Go up here and then find out the questions. I find the person with the clock a threat. Where's that? Oh, there's
So,
the event.
Todd, do you think that it's useful to think of the period that we seem to be entering as a new Cold War? In other words, is thinking about this new period as a new Cold War the best way to think through the challenges that we are likely to face in this new period?
Don't start the clock yet. Was this on? Okay. So thank you, Annette, and thank you, Michael. Dean Sharp.
There you go.
There we go. Okay, now you can start the clock. So I heard Lori giving the disclaimer that I used to give over and over and over again about these are not the views of the government, which I no longer have to give because I'm no longer in the government. She also said these might not necessarily be her views, and I find myself sort of compelled to say these might not be my views that you're hearing, especially by the end of what's today, because the ideas are really so rich and stimulating that I find myself changing my views even as I sit here. Sean spoke about the questions that the question for the symposium poses, and my take on that is that is there a Cold War? The Cold War that might be there, I think, is with China, not with Russia. With Russia, as Sean said, there's a war, right? There's nothing cold about it, and it's a different sort of dynamic. The thing that might sort of dominate the landscape for 70 years is the relationship with China, in my opinion. And the question and we have to deal with both. The question on the relationship with China, though, I think is really significantly different. The dynamics of the relationship with China over the next 70 years are significantly different than the nature of the dynamics with the Soviet Union. And but I think it's worthwhile. But I can talk later maybe. But I don't think it's really right to look at the Cold War as the analogy for thinking all these things through. I think the situation is so different in so many ways. It's similar in some ways. I think notwithstanding the fact that there is still Security Council action, it makes the Security Council less likely to sort of work our will through the Security Council in the period ahead. And of course, I would say that that is not actually new. It's certainly not new with 2022. It wasn't new in 2014 either. We had already seen the level of cooperation on the big security issues sort of coming asunder, at least as long ago as the Libya authorization for use of force by the Security Council. And from the Russian perspective, the Security Council had fallen apart as long ago as Kosovo. Right? For them, that was the Security Council failing to step up and do what it needed to do, or being looked at as authoritative. Another similarity with the dynamic, whatever we call it today, if it's Cold War or not, with a dynamic in the period looking forward as it was during the period during the Cold War, is that so much decision making will be undertaken with at least on seemingly unrelated or only distantly related issues will be taken with at least one eye on how it will affect these relationships. So in those ways, the situation has some of the features of the same dynamic, or some of the same dynamic. But there are big differences in the world now. The extent to which the sort of international agenda is dominated by global issues is huge now. You know, climate change for one. That wasn't really sort of a feature of the classical Cold War period. And you hear this constantly in the way Secretary Blinken talks about, you know, what our relationship with China is going to be. They talk constantly about this is not a Cold War. Nobody wants a Cold War. We're going to have oh my God, we're going to have competition, but we have to cooperate in a lot of different areas, and that's a sort of different kind of theme. There are several speakers said there are far more common interests we have with. Maybe less with the Russians, but with the Chinese. We are economically interdependent. In the Cold War, the traditional Cold War, the idea was sort of to defeat the Soviet Union. Defeating China is a disaster for the United States. Taking down China is not in anybody's interest. Our prosperity is tied to theirs, and their prosperity is tied to ours. And I think what that will mean over time is that there'll be significant interest, business interests here, who want to find sort of pieces of common ground where they can operate and make profits. And even if that weren't true here, it will be true in our partner countries, where business interests there will be saying, you know, push the United States, or, you know, do something to push the United States to find some level of cooperation so that we can sell our products and make money. The other thing I wanted to say, wrap up. Okay, the other thing I wanted to say, a couple of things I'll say really quickly. I think a key difference today than during the Cold War is the extent to which the polarization within the United States is the sort of dominant political feature. It makes it almost impossible for our partner countries to sort of rely on us, to feel that we're reliable in our leadership, because the leader, you know, we're for the Paris Accords, we're against the Paris Accords. We're for the Iran agreement, we're against it. So we can't lead in the same way, I don't think, over time that we did then. I think that and the extent to which other countries look at us as a model, I think, is on the decline. And you know, I don't really know what it looks like on, you know, European TV or Chinese TV, but I suspect there's a lot about gun violence, you know, people getting shot up in schools, the insurrection, and these kind of things. And I think that will make it so that we will not be. So the key element of the dynamic there is that it will be much harder for us to play the leadership role that we did in, you know, the Eisenhower administration. And I've already gone over my time, so thank you. Time expired.
And I have one more question for you, right?
Oh, okay.
Yes, and we have one more question.
Almost made it off the stage. You start a new clock, though.
Well, thank you so much. And the second question for you is whether or not we think of the period we are now entering as a new Cold War, how do you think the challenges of this new period will influence the trajectory of
the direction of international law? I think that there'll be things pushing the United States in certain directions. I think some things will push it towards, you know, playing nice and being more, being seen more as a good international legal citizen, including if the heart of your diplomacy is that we are sort of a better model than the Russians and the Chinese, you have to act like a better model. You have to not invade countries or not make it look like you don't care about international law is the best way to say that, I think. If you are, if you're saying the rules-based order is what you want, that's the most important thing, that's your defining feature, you have to play like you believe in the rules-based order. On human rights issues, I think that it's the same, that the human rights issues could be pushed in that direction. The good international legal citizen, we have to be consistently in favor of human rights and not politicize the issue and so forth. On the other hand, the need to be a leader and the difficulty in maintaining leadership could easily drive the United States in a direction of making compromises with the countries that it needs oil from and things like that. On justice and accountability issues, I'm sure Beth will talk about it more, but I think it's a huge deciding factor is how it turns out. If it ends up being successful, it'll feed more appetite for international criminal justice, which will be great. If it doesn't work, it'll be very bad for international criminal justice. That's the picture the world will get. And a lot depends, honestly, on who wins the election in the United States in 2024. If the United States keeps going back from, Trump to Biden to Trump to Biden to Trump to Biden, it makes it very hard for the United States to present sort of a leadership, to present itself as a leader. I guess that's what. Do I have any time left? Oh, yeah. No, it's okay. It's okay. Okay. I have 3 minutes left. Oh, anybody else have questions? No, that's really what I want to say.
Perfect. Thank you so much. Thank you. Thank you. This was great. And now I have the honor and a privilege to present my mentor, my dean, Michael Scharf. He has been the co-dean of the law school since 2013. He's also the Joseph Hostetler Professor of Law, and he serves as the managing director of our Public International, a policy group, and also a Nobel Prize nominated NGO. He has led USAID-funded transitional justice projects in Uganda, Libya, Turkey for Syria, and projects in Kenya and Seychelles. And during a sabbatical in 2008, Professor Scharf served as special assistant to the prosecutor of the Cambodia Genocide Tribunal. And during the Elder Bush and Clinton administrations, he served in the Office of Legal Advisor of the U.S. Department of State, where he held positions of Attorney Advisor for Law Enforcement and Intelligence, Attorney Advisor for United Nations Affairs, and Delegate to the United Nations Human Rights Commission. He's a prolific scholar with over 100 scholarly articles and 20 books, 4 of which have won National Book of the Year honors. So let's welcome him. So Michael, I have a few questions for you, if that's okay.
Yeah, shoot me your questions.
So on March 2nd, the UN General Assembly adopted a resolution using the Uniting for Peace mechanism to condemn Russian aggression in Ukraine. What is the history of the Uniting for Peace resolution mechanism?
How many of you in the room know about the Uniting for Peace resolution? Raise your hand. All right, several of you do. So in my article, I had the opportunity to research it, and I learned things I had no idea about the politics and use of this resolution. It all goes back to 1950. In that winter, the Soviet Union was boycotting the Security Council because it had sat the Taiwan government instead of the Beijing government as the China representative. They thought that by boycotting, they could veto everything because the way the UN Charter is written, it needs the concurrence of the 5 permanent members. And what they didn't realize is that the other members of the UN, including the International Court of Justice, would interpret that as saying, you have to be there and you have to vote no to veto. So they weren't there, and North Korea invades South Korea. And the United States says, Soviet Union's not here. We have a resolution to authorize a UN force to propel North Korea out of South Korea. That begins the Korean War. Soviet Union realizes it was a colossal mistake and comes back. And they start vetoing resolution after resolution. And the United States cannot get reauthorization or authorization to expand the forces or do anything else in the war. So the US comes up with the Uniting for Peace resolution idea. And that's the first surprise to me. The idea is, let's circumvent the Security Council. In a case where the Security Council has a veto by a permanent member and it's paralyzed, let's go directly to the General Assembly. And if we can get a 2/3 vote out of the General Assembly, we can do just about anything that the Security Council otherwise could do, in complete contradiction to what's written in the UN Charter. But at the time, and this is 1950, there are only about 50 countries in the UN. Almost all of them are UN allies and friends. Russia does not have so many friends, or the Soviet Union. Now, fast forward a couple years. The UN expands greatly. Most of the countries that were decolonized then become the non-aligned bloc. They are no longer voting with the US. And after the Six-Day War in Israel, they're mostly voting against Israel. Suddenly, when the US is using the Security Council veto to stop resolutions condemning Israel, they are using the Uniting for Peace resolution to go to the General Assembly and get these resolutions against Israel. The US no longer likes the Uniting for Peace resolution. So starting in the 1970s, we started lobbying to not ever use it again. Soviet Union didn't like it anyway. So after about 1980, there was never another use of the Uniting for Peace resolution. And things were nice and quiet, and the US and the Soviet Union were happy until March 2nd. The United States decided to dust off the Uniting for Peace resolution and use it again. And in doing so, I'm reminded of that old saying that good facts make bad law, because I think there were tremendous risks. There were some huge benefits as well, but tremendous risks. And I'm happy to continue to talk about those if you have questions related to that.
Yes. This is amazing. Thank you. I'm actually going to build on that, if that's okay. So what did the March 2nd United for Peace resolution on Ukraine do? And what do you think the UN General Assembly would do next, based on the foundation of the March 2nd resolution?
That's really good questions. So first of all, the resolution, which was adopted overwhelmingly by 141 countries in the General Assembly, it declares that the Russian actions are acts of aggression. And this is one of the first times in years that the UN has made such a declaration. And as we heard in the previous panel, there is talk, serious consideration of creating a tribunal to prosecute the crime of aggression. Well, the foundation for that has now been set by this overwhelming vote. The rest of it is basically it condemns war crimes, and it tells Russia, hey, stop, back off, get out of Ukraine. And full stop. It doesn't really do anything after that, but it's really setting the stage for future resolutions. And the idea was there would be a little bit of a cooling off period. We'd see what happens. And unfortunately, with Michael Kelly's announcement, I'm afraid to say that it feels like the Cuban Missile Crisis. This is not a cooling off period. Things have escalated greatly, even today, even within this last few hours. So what are we likely to see? I think we're going to see a hybrid aggression tribunal start to pick up steam. Layla said, look, there's all these political obstacles to that. Guess what? I think the political dominoes are starting to fall. And this is all about, events on the ground and how they change things. Remember what Kevin Nealor said last night. Whatever your playbook is and your plan, it always changes based on events on the ground. The second thing is, I think we're going to see some resolutions calling for sanctions. And the Uniting for Peace resolution mechanism has been used for sanctions in the past. And as Sean mentioned, that now we have all these trade laws and trade treaties that make it harder to impose sanctions, but there are exceptions, and there's this idea of authorized countermeasures. And if the General Assembly does this under its Uniting for Peace context, I think that the sanctions can expand, they can be solidified, and they can put more pressure on Russia. And then finally, I think there's the possibility of a credentials challenge. And Paul's going to talk more about this. The Public International Law and Policy Group has done some work for Ukraine on this issue. But the background is that credentials are supposed to only be used when there's two competing delegations to say which is the real delegation. But twice in history, it's been used to punish countries for doing really bad things. The first time was apartheid South Africa. And the UN said, your credential is not legitimate because you are an apartheid country, you're no longer welcome. So rather than using the way that the UN Charter says that you can expel a country or suspend a country through the Security Council making a recommendation to the General Assembly, they just did it through a credentials challenge. And the other one is the Yugoslavia situation where Serbia, Montenegro, the US said, you're not the continuation of the old Yugoslavia. I worked on this with Todd and Paul, but the Soviet Union's view or Russia's view at the time was, yes, they are the continuation, but this is a political punishment. They are being suspended. And so those two things, I think, give us some kind of a precedent if the countries of the world really want to punish Russia by keeping them out of the UN, by challenging their credentials. That's it.
Thank you so much. Thank you. So wait, we have one more question.
Okay.
And that is, what do you think are the benefits and risks of resurrecting the Uniting for Peace resolution mechanism?
All right, so the benefit is this is really high profile, and it allows there to be high profile action in the most egregious violation of international law, I would say, since the Nazi invasion of Poland in 1939. It gets around Security Council paralysis, and it could induce Security Council reform from within, because the Security Council doesn't want to lose its power. And so there may be an internal response to this where they agree to some constraints on the veto as the kinds that Jennifer Trahan described in her book. Oh, now the risks. All right. So this is not going to only be used against Russia. Anything you come up with, and this is what Michael Kelly said earlier today, you got to be careful in international law because of reciprocity. What's good for the goose is good for the gander. So we're going to see this resolution being used once again against the United States and its allies, and I think most notably Israel will be susceptible to this. And so the US, I think, made a calculated decision that it was more important to them to condemn Russia and set the dominoes falling against Russia than it was to protect Israel using the Uniting for Peace resolution. Now, the veto used to cause the Security Council to compromise. If they don't compromise anymore because they can go running to the General Assembly, then there's going to be more deadlock in the Security Council, and it's going to accelerate its demise. And if the Security Council veto was necessary to get the major powers in 1945 to agree to be part of the United Nations, if you basically emasculate the veto, and I think that's what we're seeing, there's going to become a possibility of countries withdrawing from the UN. Maybe it's first Russia, but then China, and then maybe even the United States. And I don't think we're ready to create a whole new United Nations at this point. And so there is a real risk that going down this path could be very destabilizing. That's it.
Thank you so much. Please turn. Thank you so much. And so now I would like to welcome Carsten Stan. He's a professor of law and director of the Croce Center at Leiden University. He's a professor of international criminal law and global justice. He has previously worked as a research fellow at the Max Planck Institute for Comparative Public Law and International Law, as a legal officer in the chambers of the International Criminal Court, and as a reader in public international law and international criminal justice at Swansea University. He has published over 60 articles and essays in different fields of international law, and he edited several collections of essays in the field. Please, I'd like to welcome you. And I have a few questions for you as well.
Thank you, Annette.
So to what extent have we witnessed a move from uniting for peace to uniting for justice in the practice of the General Assembly over the past decades, in cases where the Security Council fails to act?
Thank you. First of all, let me extend my gratitude to Dean Sharp and to the whole center for allowing me to be here. I think it's wonderful to be attending such a conference, coming from The Hague and seeing how this issue is really keeping all of us international lawyers on our toes. My talk and what I decided to write about was to envisage to what extent do we witness what Michael Sharp mentioned, a move from uniting for peace to uniting for justice. So what does it mean for accountability? What impact have we seen of the work of the General Assembly in this area? And I think it's very interesting because if you look back historically, international criminal justice has become so much focused on the Security Council with the ad hoc tribunals that we've somehow tended to forget that the General Assembly has played this really critical role in international criminal justice since its very inception. 1946, Nuremberg Principles, affirmed by the GA. 1950, Genocide Convention approved by the GA. 1966, crimes against humanity labeled by the General Assembly, particularly apartheid. 1974, the aggression definition adopted again by the General Assembly. And I could go on. In recent years, we've seen a certain trend to the GA to become also involved more in institutional mechanisms. It was already mentioned, it established the extraordinary chambers in the courts of Cambodia in 2003 with agreement between the UN and Cambodia. It created the Human Rights Council, of course. It created then the special international independent investigative mechanism for Syria, and that again established an investigative commission for Myanmar. So we've seen all of the steps in the practice of the Assembly, except that last step using a resolution of the Assembly itself, developing the Uniting for Peace precedent to actually create a tribunal. But proposals to that effect have actually been made. If we look at the expert group for Cambodia, it had several options which it contemplated, not only the creation potentially by the Security Council, but it mentioned even a GA-created tribunal. Then the most interesting example is the Commission of Inquiry for North Korea, which actually recommended that the General Assembly rely on the Uniting for Peace resolution in order to set up an ad hoc tribunal and to combine this with delegated universal jurisdiction by member states. In 2019, UN fact-finding mission for Myanmar again repeated the same proposal. So we have all of these demands for a GA-created tribunal. So why has this last step not been taken? I think the answer has been given partly also in previous panels. First of all, there's a fear that it might create a precedent that might come back. Every time we now have a commission of inquiry established, there would be a call for GA-created tribunal. Secondly, there are those who say we should rather invest in strengthening the ICC system rather than investing in another tribunal path. And lastly, there are those who say this is not really effective because the powers of the General Assembly are, of course, much weaker than those of the Council, but that's an argument that I would challenge.
Thank you. I have a follow-on question on that. So is the General Assembly legally entitled to create an international criminal court or tribunal?
So I would say yes, and there are different options. I don't think the IIIM is a precedent because that was a quasi-prosecutorial body, but the General Assembly established the UN Administrative Tribunal, and we've had an advisory opinion from the International Court of Justice, which validated the argument that the fact that the GA itself does not hold judicial powers obviously does not prevent it from creating a judicial body. If we look at the practice under the UN Charter, we've seen that some of the constraints on the GA have been removed. The fact that the GA can act in parallel now to the Security Council, that was confirmed by the ICJ in the Wall opinion. And the other impediment, Article 2.7, interference in domestic jurisdiction has also been reduced. So there are technically three possibilities for the GA, for the General Assembly to do that. One opportunity would be to use its recommendatory powers under Articles 10 and 13 of the Charter. And the ICJ has actually said in the Namibia case that the mere fact that you speak of a recommendation does not mean that the General Assembly cannot take determinative decision. The second option is the one establishing a tribunal as a subsidiary body, like the Security Council established the ad hoc tribunals for the former Yugoslavia and Rwanda. And here I think the General Assembly could rely on its mandate in relation to promotion of human rights and in addition, of course, the international peace and security mandate to do that. The third option would be then to use Uniting for Peace on its straight term as a precedent. And so we have different types of models that we could envisage. The easiest models would be to say the General Assembly can endorse the creation of a tribunal, and that has been suggested. We've heard it from Jennifer Trahan, and also in relation to Ukraine. I think it's uncontroversial that this falls within the power of the General Assembly. Secondly, we have the possibility to create a tribunal with the consent of the state involved. And here again, I would say this falls plainly within the powers of the UN General Assembly. Also in the context of peace operations, the General Assembly has started already in the 50s to establish peace operations with the consent of the host state. So I think there would be nothing preventing the General Assembly from creating a tribunal via resolution with the consent of the state. The most controversial option is, of course, doing it without the consent of the state. And here you would need, again, the Uniting for Peace, or you might call it maybe the Uniting for Justice formula in order to do that. What would be the downsides? Some have said such a tribunal would not be effective because the General Assembly cannot bind states to cooperate with such a tribunal. I would argue, if we look at the existing track record of tribunals, that binding coercive powers have been much less of an incentive for cooperation than other incentives, that there is political incentives for cooperation. So it's more than the question what would be the impact in relation to immunities, and here I would say that the General Assembly establishment and endorsement, particularly also for Ukraine tribunal, would make an important difference in relation to how we approach the immunity question based on the divergence of practice between, on the one hand, the ICC, and on the other hand, the little bit more restrictive practice of the ICJ under the arrest warrant case.
I have one last question for you. Is it politically feasible to envision a greater role for the Assembly in the area of accountability in the future? And how? How would this make a difference in the current discussions on prevention and repression of crimes in the Ukraine war?
So some would say, rather than empowering the GA to take such a step, we should rather invest in strengthening the ICC and in giving the General Assembly also the power to make a referral to the court. That again has been something that has been discussed both in the drafting history of the ICC statute and in the Kampala Compromise on the crime of aggression. It's clear for that to happen. I would argue it's covered by the powers of the Assembly, but obviously the ICC statute would need to be amended, not only to allow the GA the power to refer under the ICC statute, but in relation to aggression, you might also have then a very high majority, 7/8 majority, in order to enable the GA to make a referral, which could also refer the crime of aggression. So I think that route is tied to such a high political threshold that it's I consider it rather unlikely. Also, if you think about giving the GA the power to refer, it might then also have the power to defer a situation from the ICC, which many might be not wanting to take that risk. So what would I say? I think the General Assembly can play an important role in the future under Uniting for Justice. I mean, the ICC can only do a handful of cases. Domestic jurisdictions have their own flaws in relation to impartiality and fairness. We already see that with some of the first trials, also I think in Ukraine. So we need something in between. We need a level in between. And on that in-between level, I think having a greater role for the General Assembly from a multilateral perspective, I think, is one of the most credible and best options to move forward. Thank you.
Thank you so much, Professor. Thank you. And I would like to invite Professor Williams. Poora Williams holds the Rebecca Grassier Professorship in Law and International Relations at American University. Professor Williams is a co-founder of the Public International Law and Policy Group, a nonprofit group which provides pro bono legal assistance to states and governments that are involved in peace negotiations. And over the course of his legal practice, Professor Williams has assisted over 24 peace negotiations and post-conflict constitutions. He has advised governments across Europe, Asia, as well as North and Sub-Saharan Africa on state recognition and self-determination. He's a leading scholar on peace negotiations and post-conflict constitutions, and a highly sought-after international law and policy analyst, being interviewed on over 500 occasions by major media outlets. And he's authored 5 books on a variety of topics, such as international human rights, international environmental law, and international norms of justice. Thank you. Let's welcome him.
Thank you, Anat. I have to say it's a little intimidating to be here today on this panel. Ved Nanda was one of my very first mentors when I was in my early 20s and I wanted to be an international law professor. Ved gave me all kinds of amazing advice. And Todd Buchwald was my first and only boss that I've ever had. So I'm a little apprehensive. And Mike Scharf knows all my secrets. So with that in mind, I want to take a question.
Yes.
I was just going to start.
So the first question for you is the Ukraine moment a power shift for the UN?
Thanks, Anat. I want to take the term power shift and broaden it a little bit and think about back in early 1991 when I was working for Todd. And I hadn't realized it at the time, but that was the beginning of a power shift that's been in play for the last 3 decades. I showed up at the State Department a week after the August coup, which led to the dissolution of the Soviet Union. That was a power shift. Not followed, but at the same time, the dissolution of Yugoslavia, and with it, the disintegration of an effective non-aligned movement, followed by NATO humanitarian intervention in Kosovo outside of its Article 5 mandate. And now we're bumping up against the Ukraine crisis and the Ukraine power shift. So I think we want to see this power shift, which Sean mapped out this morning under the rubric of, is it a new Cold War? But basically this multitude of changes that we're seeing, and how do we deal with it, and how does it affect this clash between international law and real politique that Michael laid out. There's 3 observations that I've seen come about in these last 3 decades of this power shift. And the first is the weakness, the transparency of the narrative, the playbook that Mike Kelly laid out from Hawaii all the way through to Ukraine at the moment. And I remember the trauma as a young lawyer at the State Department when there was the Milosevic narrative, the Tudjman narrative, the Karadzic, the Mladic, and my foreign service colleagues at the State Department were like, yeah, ancient ethnic hatreds, intractable conflict, the will of the people of the Republic of Srpska, genocide, very confusing. We're not really entirely sure what that means. You don't hear that today. Putin rolled out this playbook, which has been successful for the last 50 years, and it was immediately shot down. It evaporated. We should embrace the fact that the narrative of ambiguity, the narrative of all sides are equal, has, by and large, been pierced. The second is justice. Justice is here to stay. Now, I know we're all involved on a daily basis of fighting the good fight and advocating and being a little sad at the end of the day that justice hasn't accomplished as much as we would like it to do. But you want to terrorize foreign service officers, you want to traumatize international relations students, talk about the fact that justice does not exist on their light board of knobs that they can tinker with when they're trying to employ realpolitik or diplomacy. Increase sanctions, increase démarche, decrease démarche, put something to the General Assembly. Where's that button of justice? It's not on the diplomacy playboard. It's a 120-pound gorilla sitting there. It's not yet a 900-pound gorilla, but it's an immovable 120-pound gorilla that operates independently from the political discourse. In a good way, I think, but also in a way that creates some of the risks and challenges that we've all been talking about today. And the third dimension is the power shift away from the teddy bear. So one of the things that I came away with, having spent just a couple of years at the State Department, is that the status quo was every foreign service officer's teddy bear. And they would hold tightly to the status quo because they knew the status quo and they knew that it was effective. We don't see that now. They've moved on. I'm not quite sure what our diplomatic community would be characterized as, maybe teenagers at the moment, but they left the teddy bear aside. And there's much more of a willingness to embrace changes to the status quo and new dimensions of trying to restructure both international law as well as the international, essentially, guidelines of realpolitik that they deal with every day.
Thank you so much, Paul. I have another question for you. Is Russia's Security Council seat at risk in light of this power shift?
Well, Anat, I'm so glad you asked me this question, because years from now, when Russia loses its Security Council seat, you will have all heard it here first at Case Western and behind this podium. And I'm excited that you took the bait and asked this question, because I think most people 9 out of 10 folks would meet that question with an eye roll. Just as my international relations professor in my spring semester of my last year of undergraduate met with the eye roll the question by one of my close colleagues in 1987, okay, professor, this is all great, but what happens when the Soviet Union ends? What happens when there's no longer a Warsaw Pact or no longer a NATO? Got the eye roll. Don't put that on your exam because you'll fail. We're here to learn about the Cold War in perpetuity, the Warsaw Pact, the USSR. A few years later, things completely changed. He is still a professor and still has a job. But I think we would meet this with an eye roll. Come on, enough with the Security Council, enough with the reforming of the Security Council. Oh, Mike, that's very nice about the uniting for peace, but seriously, it really is 5 that rule them all. We should be prepared for the possibility of a change. As Mike has laid out, the credentials challenge has occasionally been utilized to express displeasure with the actions of a member state, even potentially powerful member states. You could see that happening not only with the tidal wave of pushback against the Russians, but the piercing or the transparency of the playbook, the 5-point playbook, and also the willingness to change the status quo. Now, it would be technical trickery in order to suspend the credentials or to not approve the credentials of a Russian delegation. But you also have to bear in mind the Ukrainians, and as Beck pointed out earlier, are winning at lawfare. They understand lawfare, they're good at it, they're winning, and they're going to keep doing it. So as long as no one reads Michael's article on musical chairs and the rationale for why Russia held the Security Council seat or continued the Security Council seat of the Soviet Union, you could probably make a strong case, or you can anticipate the Ukrainians will be making a strong case to somehow delegitimize Russia continuing to hold that seat. Not easy, not going to happen tomorrow, but stranger things have happened in the global community. And do you have a third question for me?
Yes, the last one. Last but not least. As a result of the Ukraine conflict, is there a power shift away from the UN to other regional organizations and coalitions of the willing? And is this a desirable shift?
So, not that I knew these questions in advance or had any say in planting them or previewing them, I had to scribble new answers to my presentation after, in the last 30 seconds, Sean Murphy made the case for the relevance of the United Nations. So for 29.5 minutes, we were all tracking the drift from the UN. But as he pointed out, there's a lot of activity happening right now this week in the United Nations. So I think you're going to see not necessarily a dilution or a shift away, but you're going to see regional actors empowered to take parallel engagements. I think there is a real prospect for a court of aggression coming out of the United Nations. I also think there's a real prospect for the Europeans getting together and taking action on the crime of aggression. I think you're going to see some type of hybrid tribunal with the Ukrainians, because we've talked about this today as well. There's so many individuals that are going to need to be prosecuted. It could be hybrid with the UN, like Sierra Leone, or it could be hybrid with Europe, European Union, Council of Europe, OSCE, however it plays out. You're going to see more and more regional actors, and I don't know if we can still use this word again, coalition of the willing. Is that okay to use coalition of the willing now again? We might see more coalitions of the willing coming into play and hopefully operating within the structure of international law and international cohesion, and bringing that to bear on crises like Ukraine and other future crises that we will not be able to predict.
Thank you so much.
Thanks a lot.
So our last but not least honorable discussant, Ved Nanda. He's a distinguished university professor and the Thompson Marsh Professor of Law at the University of Denver. And he founded the International Legal Studies program in 1972. He now directs the Van Nanda Center for International and Comparative Law. The center was established in his honor by alumni and friends who have also endowed a professorship in his name. He has received the honorary doctorates of law from Soka University, Tokyo, Japan, and the Bunkelhead University in India. And he also taught and lectured at several universities in the United States and abroad. He's an honorary professor of law at the University of Delhi, India. And he holds many leadership positions in the global international law community.
That's enough.
And thank you so much for joining us today. Thank you.
If you haven't noticed, this is a mutual admiration society. Here sits a person who has been introduced to you, Paul Williams, but what he has done is absolutely admirable. And as you leave today and look at what he has accomplished, I think we all have a great deal of admiration for him. Michael, nobody in the country can have as wonderful, joyous, and substantive conferences each year as you do. Playing the band, singing songs, entertaining people, and then coming in and having international law issues that are most substantive on the front edge and done each year, year after year. I want to commend you, I want to congratulate you, and I want you to kindly join me in thanking him again for doing all this. I thought that these 4 colleagues of mine, what they have done today is a really most commendable job, because they have brought to our attention issues that are of critical importance. And I think as I listen to them, obviously there is no doubt that our appetite is whetted to learn more, think more, about this entire debate going on. Is it new? Is it old? Is Cold War, when did it begin, new Cold War? Against whom? And we'll continue thinking about it. Similarly, I think the point raised here for us about the role of the General Assembly and further strengthening it and moving toward uniting for justice and seeing that it can create tribunals and it can move further in addressing issues of critical concern in the world community. I think all of us appreciate that. Michael brought about the question of a shift, and he said that the General Assembly can do almost anything that the Security Council can do. Michael, it can't. A moment ago, I complimented him, and now should I contradict him? He's my host. He's a wonderful friend. But I have to say that General Assembly can't do all that the Security Council can do. Under the Charter, it's only the Security Council can take enforcement action. The General Assembly can make recommendations. Through those recommendations, probably things can be done. You probably recall, and Michael mentioned about sanctions. 1971, it was the General Assembly that took a very drastic step on economic sanctions against South Africa. That was the beginning of the end of that apartheid era. And 1971 General Assembly action was a very critical action. So I think the General Assembly can do, and General Assembly ought to do, that work that Michael mentioned, that under the Uniting for Peace resolution, it ought to be doing. Talked about Security Council reform. And all these efforts, you recall, France, supported by Mexico, an effort to say voluntarily, don't use veto, and a great deal of support by non-members, permanent member states. But then nothing happened. You remember that Code of Act by Act, those countries. Nothing happened. So the Security Council reform is probably going to take time, and there are efforts, but unless all permanent members either acquiesce on it, it's not going to happen. But at the same time, what Paul said about complementary work being done by the, especially under Chapter 8, all these regional organizations. I was looking at what the regional organizations have done. And because the time is up, please know that I've got a lot more to say. And these regional organizations, especially the Organization of American States, and I simply want to mention to you what the possibilities are, because the possibilities are that they can undertake, and I'll complete simply a sentence and stop there, because what they can do is they can have mobilized humanitarian support, they can commission human rights support reports, they can send envoys, they can adopt resolutions with recommendations to relevant parties, and they can do a whole lot more. And the regional organizations, especially the Organization of American States, they have undertaken many of these things. Kindly join me again. Thank you, my wonderful colleagues who have really helped us in understanding some of these critical issues.
And if that's okay, I'm going to ask Michael to respond.
Okay, sure. So I'm disinclined to disagree with anything from our mentor Vednanda, who is one of the greats. I introduced him yesterday as, you know, to some of my alums as one of the greats of his generation or any generation in international law. And largely the difference, Ved, between what I'm saying and you're saying is semantics, not actuality. First of all, I said almost all. I didn't say all, and that was key. And then I described the things that it could do. Also, there are some ICJ cases which have shifted the playing field. It used to be that enforcement measures, enforcement actions were very specifically defined as different than recommendations, but the ICJ has blurred that distinction when it talks about the implied powers of the General Assembly. I wrote a book on international organizations, and I used to teach international organizations, and one of the themes was that the organization, the United Nations, it's an organic document. It's an organic organization, and that politics have a lot to do with how the law is interpreted. And what we've seen over the years is there are parts of the UN Charter that have become dead letters. There's one, for example, that says that the General Assembly can never deal with a situation when the Security Council is seized upon it. And the General Assembly is frequently dealing with situations even though they are pending before the Security Council. There are many other provisions like that because over time the UN Charter has been shifting. So, Ved, you're absolutely right. The things that we're talking about today are not clearly, or they're in fact pretty clearly outlawed under the UN Charter. They would be ultra-virus acts of the General Assembly. But over the 70 years of the General Assembly, between what it has done and what the International Court of Justice has blessed, that terrain has changed. And I think that I largely agree with Carson. A lot of these things we're talking about that seem new, 50 years ago, they would have seemed outlandish. And I think now, and then Paul said this as well, it's a new world out there. I think the politics are lining up, and they won't be naked politics. This is all going to be described as legal interpretation, but they are definitely shifting interpretations from what was the original understanding of the UN Charter.
I need to mention to you that what I did say about Michael, it was simply nitpicking. Simply provoking, because what he has said, in reality, in international law, that's absolutely right. So what I said, discount it, don't totally ignore it, but when Michael said, there is some reality.
Thank you. Thank you so much. I'd like to open it up for questions from the audience. This is your opportunity. We've got amazing discussions here.
Well, thank you. Just on that last note, Michael, I think, is it then fair to say that when we say there's realpolitik afoot, it isn't only in relation of big powers and justice, but also in how the UN Charter is interpreted and applied over time? Is that fair?
I certainly think it's fair. And you know, when the United States first used the Uniting for Peace resolution, the Soviet Union said, you can't do that. That's ultra-virus. You're seizing powers that are reserved to the Security Council, and therefore we're not going to pay for the peacekeeping force that was authorized by that General Assembly resolution. That issue goes to the International Court of Justice, and I think to the Soviet Union's great surprise, the votes were there for the International Court of Justice to say, oh yes, the General Assembly can do that. So the way the UN is shaped, you've got the General Assembly that can make decisions and votes interpreting the Charter. You have the Legal Council that can sometimes offer decisions that are recommendations on how the Charter should be interpreted. And then you have the International Court of Justice. And through those three mechanisms, we do see realpolitik play out in the interpretation of the Charter, and then it becomes the precedent for the next case.
We have two more questions here and then here. Yes, please.
Thanks. So a couple of people have talked to us about how the Security Council permanent member veto might be modified. And I'm wondering whether, this is for the panel as a whole, will the Security Council bend before it breaks, right? Or are we going to see a rupture of the Security Council and possibly the United Nations before we see any serious modification of the permanent member veto.
Does somebody want to?
Who wants to take it on?
That's I tried to too. Yeah.
They're putting you under the fire now. Maybe this. Maybe.
Here.
I'm not sure I picked up the whole question, but the power of the Security Council ultimately rests not on what it says in the charter, but that people sort of do what it says. And that requires a certain sort of quantum of credibility and political support and so forth. And if you go below that, if you get to the point where people no longer do what it says, it quickly deteriorates. And it doesn't matter that it has this legal power, it won't be able to accomplish anything. And I guess the other side to these issues about sort of isolating Russian Jews, so a question might be, what would happen if there was a credentials challenge against Russia, and somehow it won, the credentials challenge was successful in a very close vote? And half the world, though, or 49% of the world, thought it was completely illegitimate what had happened. And then the Security Council started adopting resolutions that were very, pro-United States. The Russians would have never accepted it. And I don't know exactly what happened to the Chinese in here, too, because somehow they've maybe lost the credentials challenge also. The fact is, you might have a theory under which legally the council is taking binding decisions, but it wouldn't really affect anybody, because it wouldn't affect the people you want to affect, which are those 49%. You can rally those 51 people anyway to do things that they're, if the question is something like sanctions, you can get the 51% of the Europeans or whoever it is to impose sanctions without the Security Council doing anything. The value of the sanctions is binding everybody else. We have sanctions now, vast sanctions now against Russia. The issue of the UN is getting the Chinese to abide by those sanctions.
And I'm just going to add a real world experience that describes exactly what Todd is saying. So Libya blows up Pan Am 103. The United States and the UK get a resolution that imposes really tough sanctions on Libya. And at first, the countries of the world go along with it. But those sanctions are on there year after year after year, and countries are not getting the Libyan oil. They're getting unhappy with it. So they just start ignoring it. And what the Security Council did, because they didn't want to be disclosed as the emperor with no clothes, the Security Council doesn't really have power to force countries to do these sanctions. It's all about what they're willing to do, as Todd said. So the votes are important. So what did the Security Council do? They compromised with Libya. They created a tribunal in the Netherlands to prosecute the two perpetrators, and they lifted the sanctions. And they lifted sanctions that were already, not being effectively enforced. And that's what happens. If the Security Council is losing its power, then it is starting to get willing to make reforms and make changes, because otherwise it becomes irrelevant and it doesn't want to be the emperor with no clothes.
And we have another question here. Yes, please. Two. Okay.
So I'm having a flashback to 1993 for two reasons. One is I think I was in the State Department Legal Advisor's Office. Todd was there, Michael was there, Paul I think was still there. So that's one reason I'm having this flashback. But the other is that in this panel and the prior panel, a lot of talk about establishing a tribunal that would address aggression of Ukraine. And what I remember from 1993 when we were setting up the Yugoslav War Crimes Tribunal is discussion about what should be within the scope of its jurisdiction, war crimes, crimes against humanity, genocide, and some question, should it include aggression? And there are various reasons not to include it, including you had to try to define it. But one was that particularly the foreign service officers that Paul's been thinking about are fixated on how do we end this war, right? You're in the middle of a brutal war in the Balkans, and you want to bring someone like Milosevic to the table, ultimately in Dayton, to resolve the conflict. And as soon as you introduce aggression into the conversation, it's a crime that pretty much goes straight up to the top. And the belief was this will make it harder to bring about peace. And so the question really is, as we think about this possibility of a court addressing aggression by Russia, or in some other way bring it into ICC jurisdiction or something, should we be concerned that this will make it ultimately harder to bring about a resolution of the Ukraine situation?
Please.
So it's a great question. My recollection, which is not usually very accurate, but my recollection there was another factor for former Yugoslavia, which was that in the context of former Yugoslavia, defining aggression depended on who invaded what when, because from the Serbian point of view, an intervention into Bosnia wouldn't have been aggression into a foreign country. So it was very complicated and had this complete overlay of issues peculiar to the situation there. The broader point, though, I think is something that we have to think about. I think you had mentioned before, the question was, what's the ultimate outcome? And I would put the question, and I think there was an effective answer to that. You don't know what the ultimate outcome is, but it doesn't mean that this is the wrong thing to do. But I think the way to look at it is, if you sort of think about what happened in World War II, they had a definite plan, a definite approach, which was unconditional surrender, which a aggression prosecution fit neatly into. And the question I would ask is, not that an aggression prosecution is wrong, but the question that it has to fit in, the overarching question is, what is your plan? And it's when you watch on TV, because I'm no longer in the government, it's hard to know exactly what the plan is for ending the war, right? Is there an exit strategy? Is there an off-ramp? Or is it unconditional? It's hard to believe it's unconditional surrender. And that doesn't mean that you shouldn't be pursuing this, but what is it how does this fit into what you're trying to achieve? And I don't think they've really defined with precision what they're trying to, if you get asked the question, they tend to say things like, well, it's up to the Ukrainians. And that is sustainable for a while, but it's not sustainable forever.
I think in relation to aggression, I think the point is absolutely right, and that was precisely one of the points made also in the negotiations in The Hague, why some states were reluctant still to push more actively for the option of an aggression tribunal. I would just say that, I mean, it's artificial to isolate aggression, because we have all of the other crimes that have been committed, and so I would argue that also to focus a tribunal only on the crime of aggression is actually not the best option to move forward, because all of the experiences of the other tribunals have shown that you actually need cases building gradually up the case for the highest level of responsibility in order to have a credible evidentiary record. So I would argue, if we go for the option of a tribunal, I would much more favor an integrated tribunal looking at all of the crimes and not isolating aggression only. So in respect to the conflict with peace negotiations, in the ICC statute we have Article 16, so the option was precisely given to the Security Council to enable such peace negotiations to go forward. The problem is, if we now establish a hybrid tribunal, we don't have that Article 16 option actually built in the design. So we would have to think about how to make use of this. So I think the conflict is there. It can also be mitigated, of course, through the exercise of prosecutorial discretion. So it depends, I think, a lot also on who is behind, who's the prosecutor, how are these issues. You can defer investigations as well. So I think there are modalities actually to solve it.
Thank you. Yes, please.
I would just jump in and amplify what Karsten had mentioned, which is there are modalities to manage that conflict. But I think one thing that is incumbent upon us, all of us who are advocating for the creation, the empowerment of these mechanisms of justice, is I see you, Sean. They do interfere, as Sean was saying, they do interfere with getting to yes. And that is the predominant approach of diplomats, is to save lives, end the war, get to yes. And what we're all advocating for, we deeply believe in, it can be a barrier to getting to yes. I tend to fall on the side of the spectrum where probably would have been better to move with humanitarian intervention in Bosnia rather than bidding for it and then wait for Kosovo for a humanitarian intervention. I realize I'm on the 9-10 of a scale of 1 to 10 on that, but we are creating mechanisms that will limit the sphere in which the diplomats are able to negotiate an end to the conflict. And that's a very weighty burden to bear. I think we're doing a good job at it, but it's important to keep that in mind as we move forward.
Thank you.
To add just one thing to that. I think the world has moved on this issue. And Paul and I did a book called Peace with Justice, about this. But I think we've gotten to the point where when you have a leader willing to do crimes against humanity, war crimes, the crime of aggression, you can't make peace with them. You can't trust them. Think about what Putin would do. He'd make some kind of compromise. He'd sit back for a couple of years. He's not going anywhere. And then he's going to do it again. And we're just creating the recipe for that. So when President Biden said, he said, Putin is a war criminal. Putin committed war crimes. And his staff said, no, he didn't mean to say that. And President Biden said, yes, I did. And I think that's right. And that cat or that horse is already out of the barn. They're already investigating all the way up to Putin for war crimes. It doesn't matter if it's the crime of aggression or not. And he is not going to negotiate. And I guess, he could ask for immunity, but that's not going to happen. The world has changed. I think starting with the Special Court for Sierra Leone, the world has gotten to the point where they're not going to give amnesty for peace.
Notwithstanding all that, I simply want to remind you that Britain had taken the lead in having the willing coalition of the willing to start thinking about getting a tribunal simply to deal with aggression. It didn't come to pass, but at least that effort was going on.
Thank you. And I know we have one more question. Two more. Yeah.
Let's just do one because we're
Okay.
Okay. First, thanks to all the panelists. This has been a really rich and interesting discussion. I hate to be the one who introduces a little bit of note of a pessimism here, but let me just say, I think that there's a lot that you can't do by going to the General Assembly to get around the Security Council. And just to take one example, we've imposed really tough sanctions on Russia in response to its invasion of Ukraine. There are 40 countries in the world that have joined in those sanctions. We've put a lot of effort into getting more than 40 countries in the world. We've got nobody from Africa. We've got nobody from Latin America. There's a whole lot of reasons why they're reluctant to join in that effort. But if we went to the General Assembly and tried to get a General Assembly resolution saying, let's impose tough sanctions on Russia, we would have gotten voted down. And we knew we would have gotten voted down. We couldn't have gotten a majority for that. It's also true that although we got a big majority in condemning Russia for aggression, the vote in favor of kicking Russia out of the Human Rights Council was a whole lot closer. There were a lot of states that were willing to condemn Russia for aggression, but did not want to vote to kick Russia out of the Human Rights Council. So, and this goes back to something that Sean said in his talk about, we are really divided between liberal democracies and authoritarian states. Liberal democracies are a minority in the world these days, and a relatively small minority, depending upon how broadly or narrowly you want to define the term liberal democracy. So that means that to a large extent, I think we're looking at going outside both the General Assembly and the Security Council in order to get done certain things that we want to get done.
Thank you. And if that's okay, we'll hear the other question as well, and I'll let the panelists answer both.
No, okay. Yeah, I just wanted to say this is somewhat reminiscent of a debate we used to have in the early 2000s called the peace versus justice debate. Like, let's not go backwards in time. We had this, it was on the agenda in Kampala, and it was all about, the LRA and if it's choice of peace versus justice. And I think it really died down after that time, and we just said, both. You pursue both always, and you don't negotiate away justice. So let's not go back to this debate that I think and I do think Paul's right. There's some difficulties there. But you don't negotiate away justice. I think we all agree to that. And I just wanted to very briefly on the veto, and more in response to a question that was raised. I mean, the veto is in the charter, and it's veto proof. So you would need all permanent members to agree on doing anything to it. So it's not going to go away. It's not going to be formally changed. I'll just do a very quick plug. My book is about looking at the legality of a veto, for instance, cast in the face of ongoing genocide, which essentially then enables genocide. So there are legal challenges that can be brought through the ICJ. So that, I know, is a separate discussion, but just putting that on the table, a veto in the face of genocide, war crimes, crimes against humanity is at odds with protections due at the level of jus cogens. It's at odds with the purposes and principles of the UN, and it can be at odds with treaty obligations. So there are things that can be done, and I hope will be taken up in the future. So,
well, thank you so much, and I apologize, but we're trying to stick to the schedule, so we're going to end it here, and we're going to reconvene after lunch. Thank you.
Thank you, Anad. Thank you, Anad, and to the panelists. So we have a really exceptional lunch speech coming up. And the way this works is for the next 15 minutes, go freshen up. The lunches are here. Bring them back to your tables. You can eat during the presentation. And then we're going to have the wonderful Ambassador Beth Van Schaak. Wait, I get this wrong all the time. I'm so sorry. Van Schaak. Yes, sorry. And so don't miss it. Come right back in 15 minutes.